Uh, Today's date is August 5th, 2011. The time is 5:22 p.m. It is a Friday, and the book I'm reading from is called Business Law. This is the topic now is contracts of adhesion. A contract of adhesion is a contract, usually on a standardized form offered by a party who is in a superior bargaining position on a take it or leave it basis. The person presented with such a contract has no opportunity to negotiate the terms of the contract. They are imposed on him if he wants to receive the goods or services offered by the stronger party. In addition to not having a say about the terms of the contract, the person who signs a standardized contract of adhesion may not even know or understand the terms of the contract that he is signing. When these factors are present, the objective theory of contracts and the normal duty to read contracts before signing them may be modified. These factors may be viewed as a form of procedural unconscionability. A court may use the word adhesion to describe procedural unconscionability. All of, all of us have probably entered contracts of adhesion at one time or another. The mere fact that contract is a contract of adhesion does not in and of itself mean that the contract is unenforceable. Courts will not refuse enforcement to such a contract unless the term complained of is either substantively unconscionable or is a term that the adhering party could not reasonably expect to be included in the form that he was signing. Unenforceable contracts of adhesion can take different forms. The first is seen when the contract of adhesion contains a term that is harsh or oppressive. In this kind of case, the party offering the contract of adhesion has used his superior bargaining power to dictate unfair terms. The second situation in which contracts of adhesion are refused enforcement occurs when the contract of adhesion contains a term that, while it may not be harsh or oppressive, is a term that the adhering party could not be expected to have been aware that he was agreeing to. This type of case relates to the fundamental concept of agreement in an era in which lengthy, complex, standardized contracts are common. If a consumer presented with a contract of adhesion has no opportunity to negotiate terms and sign the contract without knowing or fully understanding what he is signing, is it fair to conclude that he had consented to the terms? It is reasonable to conclude that he has consented at least to the terms that he could have expected to be in the contract, but not to any terms that he could not have expected to be contained in the contract. Effect of illegality. General rule, no remedy for breach of illegal agreements. As a general rule, courts will refuse to give any remedy for the breach of an illegal agreement. A court will refuse to enforce an illegal agreement and will also refuse to permit a party who has fully or partially performed her part of the agreement to recover what she has parted with. The reason for this rule is to serve the public interest, not to punish the parties. In some cases, the public interest is best served by allowing some recovery to one or both of the parties. Such cases constitute exceptions to the hands-off rule. The following discussion concerns the most common situation in which courts will grant some remedy even though they find the agreement to be illegal. Exceptions. Excusable ignorance. Exceptions. Excusable ignorance of facts or legislation. Through it is often said that the ignorance of the law is no excuse. Courts will, under certain circumstances, permit a party to an illegal agreement who was excusably ignorant of facts or legislation that rendered the agreement illegal to recover damages for breach of the agreement. This exception is used where only one of the parties acted in ignorance of the illegality of the agreement and the other party was aware that the agreement was illegal. For this exception to apply, the facts or legislations of which the person claiming damages was ignorant must be of relatively minor character. That is, it must not involve an immoral act or a serious threat to the public welfare. Finally, the person who is claiming damages cannot recover damages for anything that he does after learning of the illegality. For example, Warren enters a contract to perform in a play at Craig's theater. Warren does not know that Craig does not have a license to operate a theater as required by statute. Warren can recover the wages agreed on in the party's contract for work that he performed before learning of the legality. When both of the parties are ignorant of facts or legislation of a relatively minor character, courts will not permit them to enforce the agreement and receive what they had bargained for, but they will permit the parties to recover what they have parted with. Rights of parties not equally in the wrong. The courts will often permit a party who is not equally in the wrong, in legal terms, not in pari delicto, to recover what she has parted with under an illegal agreement. One of the most common situations in which this exception is used involves the rights of protected parties, people who were intended to be protected by regulatory statute who contracts with parties who are not properly licensed under that statute. Most regulatory statutes are intended to protect the public. As a general rule, if a person guilty of violating a regulatory statute enters into an agreement with another person for whose protection the statute was adopted, the agreement will be enforceable by the party whom the legislator intended to protect. Another common situation in which courts will grant a remedy to a party who is not equally in the wrong is one in which the less guilty party has been induced to enter the agreement by a misinterpretation, fraud, duress, or under the influence. Rescission before performance of illegal act. Obviously, public policy is best served by any rule that encourages people not to commit illegal acts. People who have fully or partially performed their part of an illegal contract have little incentive to raise the question of illegality if they know that they will be unable to recover what they have given because of the court's handoff approach to illegal agreements. To encourage people to cancel illegal contract, courts will allow a person who rescinds such a contract before any illegal act has been performed to recover any consideration that he has given. For example, Dixon, the owner of a restaurant, pays O'Leary, an employee of a competitor's restaurant, $1,000 to obtain some of the competitor's recipes. If Dixon has second thoughts and tells O'Leary's the deal is off before receiving any recipe, he can recover the $1,000 he paid O'Leary. Ethics in action. Murphy, a welfare recipient with 4 minor children, saw an advertisement in the local newspaper that had been placed by McNamara, a television and stereo dealer. It stated, "Why buy when you can rent? Color TV and stereos. Rent to own. Use our rent to own plan and let TV Rentals deliver either of these models to your home. We feature never a repair bill, no deposit, no credit needed, no long-term obligation, weekly or monthly rates. Available, order by phone. Call today. Watch Color TV tonight." As a result of the advertisement, Murphy leased a 25-inch Philco color console TV set from McNamara under the rent-to-own plan. The lease agreement provided that Murphy would pay a $20 delivery charge and 78 weekly payments of $16 at the end of the period. Murphy would own the set. The agreement also provided that the customer could return the set at any time and terminate the lease as long as all rental payments had been made up to the return date. Murphy entered the lease because she believed that she could acquire ownership of a TV set without first establishing credit, as was stressed in McNamara's ads. At no time did McNamara inform Murphy that the term of the lease required her to pay a total of $1,268 for the TV. The retail sale price for this TV was $499. After making $436 in payments over a period of about 6 months, Murphy read a newspaper article criticizing the lease plan and realized the amount that the agreement required her to pay. She stopped making payments and McNamara sought to repossess the TV. Murphy argued that the agreement was unconscionable. Was it ethical to market the rent-to-own plan? Was McNamara ethically required to inform Murphy that the total price of the TV would be $1,268 under the rent-to-own plan? Something to think about. Divisible contracts. If a part of an agreement is legal and part is illegal, if part of an agreement is legal and part is illegal, the court will enforce the legal part so long as it is possible to separate the two parts. A contract is said to be divisible. That is, the legal part can be separated from the illegal part if the contract consists of several promises or acts by one party, each of which corresponds with an act or promise by the other party. In other words, there must be a separate consideration for each promise or act for a contract to be considered divisible. Where no separate consideration is exchanged for the legal and illegal parts of an agreement, the agreement is said to be indivisible. As a general rule, an indivisible contract that contains an illegal part will be entirely unenforceable, unless it comes within one of the exceptions discussed above. However, the major portion of a contract is legal, but the contract contains an illegal provision that does not affect the primary legal portion. Courts will often enforce the legal part of the agreement and simply decline to enforce the illegal part. For example, suppose Albert sells his barbershop to Bates. The contract of sales provides that Albert will not engage in barbering anywhere in the world for the rest of his life. The major portion of the contract, the sale of the business, is perfectly legal. A provision of the contract, the ancillary covenant not to compete, is overly restrictive and thus illegal. A court would enforce the sale of the business but modify or refuse to enforce the restraint provision. See Figure 1. This is Figure 1, effect of illegality. Illegal contract goes to what was one party excusably ignorant of the illegality? Yes, person who was ignorant may be able to recover damages. Leads to no, were both parties excusably ignorant of illegality? Yes, both can recover what they parted with. Leads to no, was one of the parties less guilty of wrongdoing than the other? Parties not equally in the wrong? Yes, innocent party can recover what he parted with. Leads to no, did one of the parties rescind the contract before the performance of the illegal act? Yes, rescinded party can recover what he parted to with. Leads to no, is the contract divisible? Yes, enforce the legal part. Divisible. Okay. Leads to no, hands off, no remedy will be given. Very interesting.